Earlier this week, the House of Lords published a report which strongly criticised the European Court of Justice ruling allowing individuals' requests that links to certain content be removed from search results, the so-called right to be forgotten rule. Following the publication of the result, IBTimes UK caught up with Wikipedia founder Jimmy Wales to get his thoughts on the controversy and about his role as part of Google's advisory board trying to unpick the complex ruling. I began by asking him what he thought about the stinging House of Lords report.
I agree with it 100%. I was very surprised. I didn't know it was even in the works, and I thought it was brilliant. And I think it's a little bit depressing in a way that the House of Commons, whipped to within an inch of their lives, passes emergency legislation just like that, which was the drip, and that it takes the unelected House of Lords to actually stand up for civilians' rights. So it's a weird turn of events, but there you go, there you have it. But I thought it was very, very well thought out and expressed my views really, I would say, almost perfectly. I think there's a real opportunity with drip being rushed through so quickly on the promise of a debate, a proper new debate about these issues. Unfortunately, not until after the election. Politicians never like a really serious debate about important things just before an election. I think that that's something that we in civil society and politicians who care about the issue, we really need to hold them to that and say, yeah, let's have a really serious public debate about the limits of the surveillance state and what kind of society we really want to be, because I think it's so important. Similarly for the ECJ, that ruling, it came as a surprise. It's based on legislation that existed before Google existed. The definition in it is very unclear. It clearly needs updating. And again, we need to have a really thoughtful debate, not at the level of yay privacy or yay freedom of speech, but really say, actually, how do we strike the right balance? And it's not just a spectrum, it's about getting all the details right, due process and all those kinds of things. I'm on an independent advisory board. We're all volunteers. I think that's important to know. We have been convened by Google, and there's some Google people on it, to come up with a set of recommendations for philosophically how should Google deal with these issues, but also a set of recommendations how should the law be changed to be more reasonable. We had our first meeting, which is really just an introductory meeting, going through things like how does a search engine work, which I didn't need, but some of the other panel members who are more law professors and things like that may have needed. We had a presentation, not from Google's perspective, but from an outside lawyer, an outside expert, explaining the lay of the land. How does the European law work? What are the different European laws that have impact here? And so that was a sort of an introductory meeting, and now we're going to go through in 6 cities around Europe and have public hearings, bringing in experts to give us sort of input so that we can compile a report that's hopefully useful. I don't think it makes any difference to the ECJ. I mean, that's a court, and courts do what courts do. I think it will make a difference to European Parliament, who have quite often come down on a reasonably correct side on a lot of digital issues. And I think there are a lot of people there who realize that wherever you stand on privacy and freedom of speech, we almost certainly don't want to organize society so that Google is forced to be the arbiter of history. That's a really strange thing to do, and that Google is forced to take down links based on criteria they've developed themselves and so on. It's just bizarre. I mean, you need court oversight if you're going to censor a newspaper. That's clear. Even if the internet were somehow had borders, that still makes that doesn't change the fact that censoring a newspaper is a human rights violation. And so while part of the tension that arises is that where there are optional choices in the law where you could say, well, you could do it this way or that way, and either way would be fine from a human rights point of view, but different countries are going to do it differently. Okay, that introduces some tension. But there are some things like, this is a story published in a newspaper, and you're not allowed to link to it. That's just wrong, and it doesn't matter what culture you're in. I don't know. The sooner the better, I hope. I do think it's something that is, it's so clearly broken. Again, no matter what your ultimate position is on privacy, this solution is just clearly the wrong one, that the European Parliament needs to act quickly to update the law to make it clear.